27 million messages and funneling them to global law enforcement. Xenia Cotter is a commander with Australian Federal Police speaking here in California.
Police in near real time accessed messages.
Many of the takedowns involved drug smuggling, but went as far as murder. Alex Stone, ABC News.
Murder charges for one of two suspects in connection with the Southern California road rage shooting, which killed a 6-year-old boy. Orange County prosecutors charged Marcus Ariz with murder and the death of Aiden Leos. Ariz's girlfriend, Wynn Lee, is charged with accessory after the fact and carrying a concealed firearm. You're listening to ABC News.
From the KMET Weather Center for Beaumont, Banning, and the Pass area. For this afternoon, sunny skies, a bit of a breeze, high temperature near 80. A mainly clear sky for tonight, low 56. Sunny skies for Wednesday, high 82. Redlands this afternoon, it's going to be mostly sunny with temperatures near 80. The Desert City's plenty of sunshine. We'll have a high of 94. I'm meteorologist Jim Minaldi for Smart Talk 1490. KMET.
Take KMET 1490 AM with you everywhere you go by downloading our free smartphone apps found on the KMET website, KMET1490am.com. You can also go to the Google Play Store or the Apple App Store on your phone to download the free app. Now you can listen live or play any of your favorite programmers' podcasts using your smartphone. Go to KMET1490am.com and download your free phone app today.
The following is a paid program. Views and claims expressed are those of the program producer and are not endorsed by this station. Opinions expressed are not necessarily those of radio station KMET, its management, employees, or affiliates. The WK Law Power Hour is here to take you from zero to hero in legal knowledge in 60 minutes. A law firm with 40 years of experience is ready to give you legal guidance you need for free. What could be better than that? Amazing stories about actual cases, interesting and informative guests. Listen, watch, call in. Come ready to learn. And now your host for WK Law Power Hour, Paul Wallin.
Good afternoon, everybody. I'm Paul Wallin. I'm the senior partner of Wallin Klarich, a very successful law firm in Southern California. I've been a lawyer for 40 plus years, believe it or not. I know I don't look that old if you're watching this on TV, but it's true. And basically, I've devoted my life to giving people legal knowledge and helping people when they have legal questions or problems. The purpose of this show and the goal is two. First, it's to answer your legal questions on many areas of law. Those kind of questions that you've been wanting to ask a lawyer, or you're afraid you'll be charged too much money, or you've been putting it off, or you just want a fresh perspective on a case you have. And the other purpose of this show is to talk about legal cases that are going on that affect all of us. For example, we'll be talking later in the show about abortion rights and a woman's right to choose whether to carry a child to term or not, and a recent case in Mississippi that could basically eliminate a woman's right to choose because of the former president's packing the court with 3 conservative justices. And with those two goals in mind, we start the show. The first part of the show, we take calls, and the phone number you can call in is 951-922-3532, and you can ask any question, and that's between now and 3:15. And then at 3:20, look at your watch, at 3:20 to 3:45, you can call in, and those questions should be anything related to child custody, child visitation, child support, anything like that. You can also go on TikTok if you have TikTok, and my handle is @BeachLawyerPaul, and you can ask a question, and I'll read the question online. I'll read the question on the air, and I'll answer it for you. You can also go to pjw@wklaw.com, and I can get the question there. The kind of areas of law we practice are criminal defense, traffic tickets, restraining orders, expunging your criminal record, family law, child custody, DMV matters, anything like that, we handle it. Our firm was founded 40 years ago. We have helped over 250,000 people. That's a lot of me. That's 250,000 people that we have helped or more with their legal questions. We handle cases through all of Southern California in the areas I told you about. And as I said, today we're going to be concentrating on our discussion with a brilliant family law lawyer, Neelam K. Kahlon-Pfister. She's a lawyer with our firm. She handles family law. She's been doing family law for over a decade. And if you have a question pertaining to family law, hi, Marcy. How can I help you?
Hi, I just had a quick question. I was recently in a car accident and I don't have insurance. I also just lost my job and I couldn't pay the premium. The cops came and took a report, so would I be losing my driver's license?
Yeah, you know, this is a real problem in California, especially for people that have limited income. The answer to the question is, if you're in a car accident and there's over $500 in damage, and that is reported to the police then have to ask for your insurance information. If you don't have insurance, they have to report it to the DMV. Then the DMV is going to send you a letter, and that letter is going to say your license is going to be suspended for a year. And unfortunately, there's nothing you can do. There's no provisional license. So I wish that wasn't the case. I guess it's a lesson, a life lesson, that having car insurance is for your protection if you're in an accident and to protect the other person, right?
Yeah.
And if you didn't have it, I don't know if you can't pay that person off, that other person's going to be pissed off, right? But unfortunately, yeah. Unfortunately, the answer is yes, you're going to lose your license. Unless the cop screws up and doesn't submit the paper to the DMV.
Oh, okay. Thank you for answering my question.
Oh, you're very welcome. Have a great day.
You too. Bye-bye.
Okay, bye. So, Neelam is a brilliant family law lawyer, and we're going to be answering a whole series of questions that I will ask her about. But also, you can call in at 951-922-3532 between 3:15 and 3:40. And if you have a pending family law question, just call in and we'll be glad to answer it. Another thing we're going to talk about today, as I mentioned, is the influence of the former president, Donald Trump, and what impact, even though he's out of the White House, thank God, what impact will he have going forward? First of all, of course, people that don't believe in reality think someday in August, to be determined, he'll be anointed president and he'll be flying in on a jet and maybe parachute in, and Biden will be ushered out. But those who are living on planet Earth know that's insanity and Trump will not be president again. But what you have to understand is when a president appoints a lot of judges while he's president and they're confirmed by the Senate, it can affect the laws of this country for decades. And the first one I mentioned I was going to talk about is a woman's right to choose. In 2019, Governor Kemp, the governor of Mississippi, signed a law that said you can no longer legally terminate a pregnancy when you can listen when the fetus has a heartbeat. That is between 6 weeks and 15 weeks. Of course, in some cases, a woman doesn't even know that they are pregnant by that time. And that means they would lose the right to terminate the pregnancy. 40 years ago in Roe versus Wade, the Supreme Court said that a woman has the right to terminate her pregnancy until the child is considered viable, and that's 24 weeks. Mississippi legislators said, well, we know now with science that some babies can survive as early as... Jacob, how can I help you?
Hey, Paul, how you doing?
Fine.
First of all, I wanted to say I'm a huge fan of your TikTok account. That's how I found this show, so thank you for that. And I just had a quick question. My brother lives in California, and he's been coming home from school with bloody noses and told our family that this kid down the street waits for him and opt to sit him on school grounds. They sneak up on him and kick him, and this time they punched him. Can we do anything legally?
Wow, that's horrible, and I'm really, really sorry that happens. You don't know what goes on with kids these days or teenagers. Yes, there is something you can do. The first thing I want to caution you is not to take any direct action to reciprocate against that child. You have two options. You can either go to the police, and you can obviously explain to the police the situation. That's in every state. I'm sure in Tennessee, that is assault and battery, and the juvenile can be prosecuted in the juvenile court, and the parents will have to go to court with him, and he can be sentenced to juvenile hall. And of course, if there was any medical bills associated with what happened, they could have to pay restitution. Another option, if the court doesn't take it seriously, if the DA's office for some reason doesn't prosecute him, you can ask for a restraining order. You would actually serve the parents of the minor, because they're guardians, and they would have to come to court with the minor, and a judge would decide whether to issue a restraining order. And if the judge believes what happened is true, assuredly the judge would do that. And then if that child comes within, I think it's 100 yards of your son, he could be put in jail. So there are two options you have when that kind of horrible thing happens. Okay?
Oh, wow. Awesome. Thank you so much, Paul. I appreciate that.
No, you're very welcome, and thanks for calling.
Thank you. Bye-bye.
Okay, so I was talking about before the call that Roe versus Wade decided that a woman had the absolute right to terminate a pregnancy up to 24 weeks. Now Mississippi has said no, and that means that a young girl could be raped by her father, by an uncle, or anybody, and it means that at 10 or 11 years old, and she wouldn't have any idea that she was pregnant. And if, in fact, they discovered the pregnancy after they found a heartbeat, she would be forced at that age to carry the child to term. That's what Mississippi law says. Luckily, the federal district court, of course, it was appealed, and the federal district court said, no, Mississippi, you can't do that law. And then Mississippi appealed to the Federal Court of Appeals. And the Federal Court of Appeals said, no, Mississippi, Roe versus Wade is the law, you can't change it. But guess what happened? Mississippi appealed again. And now guess where the case is going? It's going to the United States Supreme Court, where there are 6 conservative judges and 3 liberal judges. And one of those judges is Amy Barrett on the court. And Amy Barrett took Ruth Ginsburg's place. And if you know about Supreme Court history, Ruth Ginsburg was one of the most pro-right to choose justices ever. And she was replaced by Amy Barrett, who is one of the strongest anti-abortion justices. So there is a chance that 5 justices are needed to overturn Roe versus Wade. And they would sort of have to do that to say the Mississippi law would be okay. And if they say it's okay, then that will mean that this will go to every state that in the South for sure, or most southern states, that don't want people to have abortions. And then we'll have women going back to using hangers, and we'll have doctors being prosecuted again. So don't think that Donald Trump being president has not had a horrendous influence for years and decades to come, because he has, not just on that case, but on other cases as well, which we'll be discussing after the break. After the break, we're going to be talking to Neelam Kahlon-Pfister, who is a brilliant family law lawyer, and she's going to be going over so many questions with us, and you're going to be getting a lot of legal education that can be helpful to you. I hope you don't personally ever need it, but almost every family needs a good family law lawyer, because something comes up with your uncle, your aunt, your mother, your father, and we will be able to help you and answer those questions. And that will be after the break, which is coming up very, very soon. So keep watching, and if you have questions, call 951-922-3532. That's 951-922-3532. Or you can go to wklaw.com for more information about our law firm. There's hundreds of pages of content there. And I think the commercial break is about to come right now.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years' experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
Hey, are you okay to drive? Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV in court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
When you have a warrant for your arrest, it's a very scary time in your life. When you drive a car, you have to be extra careful that you do not commit any sort of moving violation. You have to be looking over your shoulder, checking for police officers. Will you be stopped and thrown in jail? What a horrible feeling. For over 40 years, we have helped thousands of persons resolve their problem with having a warrant. In some cases, we can actually appear in court for you without you being present to recall the warrant. Depending on the facts of your case, you may never have to do 1 minute in jail. Stop living in fear. Call us now for a free phone consultation at 877-4-NO-JAIL. That is 877-4-NO-JAIL. Or go to wklaw.com. Isn't it time to get your life back? We will be there when you call.
Hi, we're back, and we're very excited to be talking about family law with Neelam Kahlon-Pfister, who is an experienced family law lawyer, and she obviously also works at our law firm helping people with family law matters. So, welcome to the show, Ms. Pfister.
Oh, hi, good afternoon. Thanks for having me.
No problem. So, can you first of all start and tell us how you decided to become a lawyer?
I was in my junior year of college at UC Santa Cruz, and I had a really good friend, who had mentioned going to law school. And, I thought, well, I like to write papers. I like to read. And my parents always said I was very argumentative. So I thought, well, sure. She kind of convinced me, and I guess I caught more or less the bug. And from there, kind of my interest peaked, and I pursued it.
And then where did you go to law school?
I went to school at Thomas M. Cooley Law School in Lansing, Michigan. It's now called Western Michigan University School of Law.
Were you living in Michigan at the time? I mean, before you went to law school, or did you have to relocate to go to that law school?
No, I relocated to Michigan. So I'm originally from Southern California. I grew up in the Covina, West Covina area. I went to school, high school out there, and then I went to UC Santa Cruz for undergraduate studies, and then I went to law school in Michigan.
Got it. And you've been a lawyer for how long now?
I have been a lawyer for 11 years, a little over 11 years.
And what is the primary area that you practiced while you've been a lawyer, more than anything else?
I have primarily practiced family law.
Okay. Why did you choose to practice that area of law? I assume child custody, visitation, divorce, as opposed to any other area. What piqued your interest in it?
Well, when I took the California bar exam, you know, it was definitely a lot different than some of the things I learned at law school in Michigan. But, you know, community property law, that part of the bar exam, I found that interesting. And I kind of stumbled into the area. We had a close family friend who knew an attorney in the Pomona area who did family law, and she was looking for some help at her office. So I just contacted that individual, and then from there, I kind of just fell into it.
I see. So after you started doing it, Teresa, okay, how can we help you?
Hi, I wanted to see if you could help me out. So I've recently been married, and I've only been married for 5 months, and my husband just told me he doesn't love me, that he only got married so that he could become legal in the U.S. and get a green card. I was wondering if you could help me out. Is there something that I can do to end the marriage quickly and not let him get away with this?
Neelam, why don't you handle that?
Oh, yes. Hi. Thanks, Teresa, for asking that question, because it's a very good question. You can file for what's called an annulment. That means that you've been married for a very short period of time, and you can file on the basis of incestuousness, bigamy, the person was of unsound mind, or you were on unsound mind. There's a prior existing marriage. The age at the time of the marriage, let's say if you were under 18 years of age, and fraud, which in this case would apply to you. Either party got married or registered as a result of fraud. So you can petition the court for an annulment, and in your petition you would mention that the other spouse perpetrated a fraud in order to obtain their citizenship. That's the only reason that they married you. So.
And then if that is granted, that will mean what as to her marital history, if the annulment is granted?
Then it's like she was never married, basically. It kind of vacates that. So she's free to get married again.
And Teresa, probably also, he won't get away with this because if he's no longer married, he can't use you to become get a green card or become a citizen.
Yeah, that's right. It would open him up to all sorts of immigration consequences as well.
Right. Do you understand that, Teresa?
Yes. Thank you so much for your help.
Okay, that means you're not SOL. That means you have a good chance if you follow her advice. Okay. Okay. Great. Thanks for calling.
Thank you.
Okay. So the next thing, I think that good thing people would like to know is, why don't you explain to start with, how does a person get a divorce when they've decided that they don't want to be married anymore? What do they do?
Well, you have to file what's called the summons and petition with the court. It's judicial council forms. It's FL 100 and FL 110. The petition is FL 100 and the summons is FL 110. So basically, those are the two primary documents you file, and it tells the court that yes, you're interested in filing divorce on whatever grounds you choose within the petition, and then it starts the process from there once you file. You have to meet the jurisdictional requirements as well to file divorce in California, meaning that you've been a resident of the state of California for 6 months and a particular resident of that county in which you filed, or which for 3 months.
Okay, and then is there a filing fee or is it free? How much does it cost?
Generally speaking, in Riverside, generally speaking, in Los Angeles, in San Bernardino County, the filing fee is $435. That's the what they call the first filing fee, first appearance fee. In Riverside County, the first appearance fee or filing fee is $450, and that starts the process. They do have what's called a fee waiver. That's a whole set of forms that you have to fill out and ask the court to look at your income and also your respective expenses, monthly expenses, and they'll determine from there if you qualify for a fee waiver or reduction in fees.
Okay, and then after you do that and you pay or you get a fee waiver, you then have to serve the other spouse, right? Serve the papers on them, right? Can you serve it by mail? Do you have to serve it in person? How do you serve them?
Well, service, of course, means putting the person on notice that you filed for divorce. So it could be anyone who's over the age of 18 who is not a party to the action. So that would not be you, of course. Some people can go use process servers. They can contact their local sheriff's department. You could have a friend or a relative serve the paperwork as long as they're over 18 years of age. So that's personal service. If you were, let's say, to serve the person by mail, then they have to fill out what's called an acknowledgement and receipt and sign that and return that to you, saying that they have acknowledged that they've received the papers in the mail and they're accepting service.
Once the person is served, how long does the person have to reply to your petition? And what is the reply called?
So generally, a person has 30 days, calendar days from the date they were served, to respond, and that's called a response to the petition. So that is the FL 120. And so the clock starts as soon as they're served. So if they do not respond within the 30 days, you can petition the court at what's called a default. You can ask for a request for default.
And what does that do? If you ask for a default, what happens?
Well, when you ask for a default, you're asking the court to proceed with your divorce papers because the other party hasn't answered, and you're asking the court to award you whatever you had outlined in your petition for as like a community property and separate assets.
So let's say, okay, go ahead.
Oh no, and then in addition to your default request for default, you would file a default judgment, further explaining to the court that these are the court orders that you'd like the court to put in place.
So let's say you have a house that's worth $300,000 and you guys own it. You don't know anything on it. $300,000. That means that if the person, and you say, I want all that house. And if the other person doesn't answer, the court's going to give you that whole house.
I mean, they will, because the other person had the opportunity, the notice and opportunity to hire an attorney. Now, keep in mind, when you file for default, you have to, when you filed the request for entry of default, the FL 165, you also have to serve a copy of it to the other side and acknowledge that you've mailed a copy to them. So they're on notice then that you have petitioned the court for default. And if you get a default judgment, they have statutorily under the Civil Code of Procedure, Section 473B, they have 6 months to set that default judgment aside. So if the court awarded you the $300,000 residence and they are not in agreement with it, well, then they should sit on their laurels. They should act right away and hire an attorney and petition the court to set aside that default.
But does that mean that if the other person got actually served and sat on their butt and did nothing, they can come into court 170 days later, right before 6 months, and say, I want to set it aside, and the judge will automatically do it, even though they could have come to court when the case started?
Well, I mean, they have to, provide facts as to why they didn't respond. Were they incapacitated in some sense? They could, I guess, the catch-all is excusable neglect. They were, busy with life. They didn't have the funds to hire an attorney then, but now they do, and they didn't mean to neglect their case, but they would like to participate fully in it.
Right, and so is it presumed that judges are supposed to be liberal in set aside a default within 6 months? Or does it still hold them to the standard in your experience?
it still holds them to the standard. They still have to prove their case as to why.
Okay, why they didn't do anything.
Yes.
Okay. A lot of people ask me this on TikTok and all. What happens if a person is not legally divorced, but they think they're legally divorced and they marry another person?
You know, I've encountered those situations, and I you know, it's I guess it's mind-boggling to me how someone could, you know, go to another county and get married without validly showing a divorce decree. But I know that it happens. I mean, I can't say that all the agencies, there's a central system where, you know, there's a thorough records check in place where they're seeing, you know, who's, you know, if you've been married before.
Okay. Hi, Andy. How can we help you today?
Hi, Paul. Sorry to interrupt. Just have a quick question. So, unfortunately, I think that my former spouse is molesting one of my kids. Am I able to leave the state and go live with my mother for a bit? We have joint legal custody, but I don't want to get in trouble with the state for taking the kids without his permission. But I'm convinced he's harming one of my daughters.
Wow. That's a very serious, and also that's a very interesting area of law, right? You want to answer it?
Oh yes, I you know, Andy, I am first and foremost, I'm so sorry you're going through this. This just must be like just very nerve-wracking. So in that instance, I would say you need to file what's called an ex parte. That's an emergency hearing with the court, and you need to file that right away. You need to tell the court that these are your suspicions, you know, provide, you know, very thorough explanation as to why you think this is taking place. Maybe your children have said something. Maybe you've already, you know, taken steps and you've contacted the police and law enforcement has interviewed your children. CPS is involved. All that needs to be presented to the court so they can grant your emergency orders and allow you to leave the state.
But what if the child's like 4 years old? And what if the child reveals only to the mother, let's say, or only to the father, let's say, right? And the father believes the child, but then they take and then they call the police, and the child is embarrassed or doesn't say anything to the police, so they don't file criminal charges because the child's so young. Will the judge still allow them, based on just the husband's word that the child said that, to deny the other parent further contact and let him leave the state? Or how does that go?
No, in that instance, because there's not enough evidence to support that claim. I mean, it's more or less hearsay, and the hearsay of a child, you know, a child who may not have the understanding of, you know, complete comprehension of what they're saying. Maybe they're just repeating what they've heard from other children, or they've been coached by the other parent to say this.
So if the court, go ahead, finish.
What I'm saying is, if there's an investigation and CPS determines that it's unsubstantiated, then that, you know, kind of furthers the other parent's position that the parent that wants to leave the state should not be allowed to with the child.
So the bottom line is, if you file the ex parte and the judge says you don't have enough information yet, so I'm going to deny it, what happens if the parent is so sure that his child was molested, and he leaves the state to go to be with his mother to protect the child? There's going to be consequences then to that parent, right?
There will, yes, because the other parent can file child abduction charges.
And that's a criminal charge.
That's a criminal charge, and they can also, use the family law court, file their own emergency hearing to try to bring the other parent back into the state with the child.
But Andy, if that's the case in your case, it must be unbelievably frustrating to you. If the judge says no, you have to let your child go for visitation with someone that you believe is molesting your daughter. That is what would be, and is horrible, right?
Yeah, so I can't just pack up and leave tonight, let's say, and then just fight the courts on it later?
I guess not.
No, yeah, because unfortunately, if it's not found to be credible, the allegations are not found to be credible, then the court's going to force you back to California because the other parent has rights. You have joint legal custody. So,
That's right.
that means something.
Okay.
So
well,
you
thank
can't
so
you
much.
can't just leave the state, or you're subjecting yourself to criminal prosecution unless a judge says that there's enough evidence that they fear that your child is being molested. But if you leave the state without a court's permission, you're going to get in big trouble, and that's why it must be we feel so sorry for you right now.
And is this something that your guys' firm could help me out with?
Of course. Yeah, this is what we do every single day. And obviously we weren't there. You obviously believe your daughter, and we just you're our client, and so we advocate for you, and we hope she wasn't molested, but if she was molested, we pray that she tells it to a doctor, a psychologist, a police officer, that would be, or a social worker, that would corroborate your story, and it won't look like you're influencing the child because you don't want the other parent to have custody. You understand?
Mm-hmm. Okay.
So that's why you should go to the police, you should talk to the social worker, and have your daughter interviewed by them. Okay?
Okay. Well, thank you so much for your help.
No problem. Thanks for calling, and good luck.
Thank you. Bye.
Okay. It's amazing how many different kinds of family law problems a family law lawyer has to deal with. The gamut, so many different things: child support, child custody, divorce, so many different things. Can you tell? Someone asked me, what is a summary dissolution, and how is that different than a normal divorce?
So a summary dissolution is a simple and quick process, simpler and quicker than a traditional divorce because there's few court filings, and it basically tells the court that you come to a written agreement. You have very few assets. There's there's no children involved, and you just want this to be done sooner than later.
And how does it speed it up by doing it that way?
Well, in the sense that you still have to, it still will take the 6 months to do so, but it's just, there's a lot less paperwork. There's fewer court hearings, fewer hurdles that you have to jump through in terms of paperwork that you have to comply with procedurally.
Okay, so in terms of hiring a lawyer, if you have a house and you have children, is it a good idea to hire a family law lawyer because of those kind of things that are at stake?
It is most definitely, because the family law attorney, an experienced one, will help you parse through, all the legal system in terms of what you're entitled to, what things are putting a value on assets, a reasonable visitation plan. Let's say if you and the other party are not, that's a contentious issue, spousal support, child support. So it is very important when you're thinking of filing for divorce to hire an attorney, especially one that's very experienced in family law.
I mean, if you have like 2 young children, and if you don't get a lawyer, and let's say you have children that are like 4 and 5, and child support can go till they're 18, right?
Yes.
At least. Okay. So if you represent yourself and the judge awards $200 a month for each child, where if you hired a good lawyer, they could have got you $500 a month. Imagine you're losing $300 a month for years and years and years. It could be tens of thousands of dollars that you wasted by not getting a lawyer to make sure you do it right. Basically, right?
Yes, that is correct.
Okay. Another question I get always is, what do I have to prove to the court? What reason do I have to tell the court why I want a divorce?
I mean, the most common reason, it's on the FL 100, the petition, is irreconcilable differences. California is a no-fault state, so it does not matter, unfortunately, if the other person's committed infidelity, they've had a gambling problem, they've had a drug addiction, other substance abuse, alcohol issues. Irreconcilable differences is the general, catch-all category to get a divorce.
So that means in California, if you wake up one morning and you don't like the fact that your spouse made bad coffee and you say, I want a divorce, you can get a divorce. The court doesn't care, and they don't look into that.
That is correct. The court will not pry into those matters.
Okay. Okay, so does that also mean often someone calls us for a divorce and they say, I have proof, absolute proof that my husband was cheating on me. So I want more spousal support, or I want more child custody because of that. And the truth is, oh, okay. Okay, go, well, just one second. So am I right that the court's not going to care that that person was committing adultery, right?
No, not in that instance. No, the court would not care. But maybe, I mean, for spousal support, perhaps it goes towards their spending habits if they're spending money on the
like prostitutes, you mean?
Yeah, person that they're having the alleged.
Oh, I see.
In
Got
terms of discretionary income, that they could be, the court could, give you more in spousal support.
I see. Okay, Marcy, what would you like to know?
Hi, I actually found out my husband was seeing another woman and I wanted a divorce, but I don't have a lot of money. We don't have much property and we don't have kids, so what would I be able to do?
In that sense, Marcy, as we had mentioned, you can qualify for summary dissolution. That means you've been married. How long have you been married for, you said?
Not a long time.
Well, you've been married for less than 5 years and you have no children. If you don't have any property, if your debts are less than $6,000, you would be a good candidate for summary dissolution.
Okay. Okay. Thank you.
Okay. So basically what we're saying to people is, even though you feel badly hurt that your husband was cheating on you or was gambling money that you didn't know about, there's really nothing the court's going to do to punish the other parent for those acts, correct?
Well, I guess, I guess it's a bit of a loaded question because it could those issues could go towards child custody and visitation, and the court could award you more time if you guys are in a contentious custody battle based on the other parties' actions, because it's showing that they're not acting in the best interest of the child. They're not a fit parent. They have all these issues that they.
You mean like if they have a gambling problem, they're not going to be as good a parent because they're going to not devote their time to their kid, but rather going to a casino or something. I think that's what you mean, right?
Yes, yeah, things of that nature, and that of course opens the door to possible substance abuse issues as well. Okay.
Okay, the next thing that many people don't understand, and it's really important that you explain it, there are two different kinds of custody in California, right?
Yes, there is.
Okay. Why don't you quickly tell us the difference between those two before we have a break?
Okay, so joint legal custody means that both parents share in the right and the responsibilities to make decisions relating to the health, the education, and the welfare of a child. Joint physical custody, going along with joint legal custody, means that each parents have a significant equal periods of physical custody with the children, and that's usually on a 50-50 basis. Sole custody means that the one parent is responsible for all the decisions relating to health, education, and welfare of the child, and they would also have sole physical custody, meaning the child would reside with them 100% of the time.
Got it. Neelam, I want to thank you very much for coming on. Obviously, we only covered half of what we wanted. You're going to come back. Will you please come back on another show so we can finish all these other things that are so important?
Oh, sure. Absolutely. Thanks for having me on.
And Neelam is in our Riverside office, but she handles family law cases in basically most of the offices we have in Southern California. You're free to call us at 877-466-5245 anytime, and we'll be glad to give you a free phone consultation, and it will obviously cost you nothing because we just care about you. And we'll be heading to the commercial right about now. Thank you again, Neelam, for coming on.
Oh, thank you.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years experience and attorneys who work in your local courts, Wallin and Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin and Klarich. 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin and Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin and Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin and Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
Hey, are you okay to drive? Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV in court hearings, it could mean losing your license, your job, and even your freedom. But Wallin and Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin and Klarich can make the difference between jail and freedom. Call Wallin and Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When you are facing a serious criminal charge, it means you may be looking at many years in prison or doing up to 1 year in county jail. Most people do not know who to turn to in their time of need for expert legal guidance. What you do next can make the difference between ending up in prison for many years or having your charges dismissed and you going free. At this very critical time in your life, you need Wallin and Klarich fighting for you. Wallin and Klarich has 40 years of criminal defense experience, and they work very hard to do all they can to win their clients' cases. Wallin and Klarich has a team of 10 criminal defense lawyers fighting for their clients every day. They help people with cases pending throughout California. They successfully defend cases dealing with murder, sex crimes, all felonies, as well as misdemeanors. Check out wklaw.com for some real client success stories. They offer a free phone consultation to answer your questions. Call them toll-free at 877-4-NO-JAIL. That's 877-4-NO-JAIL. They will be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin and Klarich at 877-4-NO-JAIL. Wallin and Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
Welcome back. The show is back on. We just had a tremendous 27 minutes with Neelam Pfister, a great family law lawyer. If you have any family law questions in Southern California, you can call us for free, toll-free, 877-466-5245. Before the show's over, I want to talk about a couple cases that are extremely important that are before the Supreme Court of the United States, and they affect different groups of people. Even though people thought when gay people were allowed to get married, that meant they would have equal rights. That's not necessarily the case. 2 gay guys wanted to adopt a child in the city of Philadelphia. Philadelphia has a law that says you can't discriminate against gay people. The Catholic Church runs an adoption agency, and they said, Joseph, how can I help you?
Yeah, hi. So I have a question. I'm in a little bit of a situation. I was put on probation almost 3 years ago for petty theft, and last week I went into Target and I changed the price tag. They caught me, and the cops came and gave me a citation. I have to appear in 3 weeks, and I'm scared about going to jail and losing my job. And I also have a 3-year-old that I'm raising by myself. I'm a little nervous and scared, so what can happen to me?
Okay, well, you should be a lot more than a little nervous, Joseph, because you are facing two different cases. First of all, when you were put on probation for your first petty theft, you promised the court to not commit another crime. And the worst crime you can commit is the same crime you were put on for probation for. So now you've committed the same crime, which means you didn't learn your lesson the first time around, and the judge is likely want to put you in jail on the probation violation. Plus, you have a whole new case where you can do additional jail time. The first thing, you definitely need to get a lawyer to represent you. If you can't afford a lawyer, you have to wait to the court date and ask the court to appoint a public defender. They're good lawyers, they're just normally swamped. If you can come up with money, you should hire a good private law firm, depending on the county where you live. And you definitely should get into some kind of shoplifters therapy. There are classes, there are programs that can help you. Because when you go to court, if you haven't told the judge, yes, I'm either seeing a therapist to see why I'm doing this, or I'm in a shoplifters class, the judge is going to be very pissed off and is going to want to put you in jail. And of course, the fact that you have a 3-year-old, I don't know where the mom is, if she's around, but you have sole custody, you better get your parents or someone, and basically your lawyer's going to beg the judge to give you a third chance and give you maybe community service, because otherwise, obviously, your kid could be taken by social workers. So I feel really badly for you. Please don't steal again. Whatever it is, it's not worth it. It's one thing if you were stealing bread, for your kid, but please don't steal anymore, and definitely get a lawyer to go to court with you or ask for the public defender before you say one word to the judge. Okay?
Got it. Thank you so much. I appreciate it for your knowledge.
No problem. Thank you for calling. So anyway, I was telling you about this case. Donald Trump appointed conservative judges to the court, and basically they refused to give 2 gay guys the right to adopt a child. Obviously, the only reason they're not giving the child to these 2 men is they're gay. And so Philadelphia told the Catholic Church, you cannot be in the adoption agency business anymore. And that is heading to the Supreme Court. And if the Supreme Court says that the Catholic Church can refuse to give 2 gay guys the right to adopt, that means that'll spread to other states, and gays will just really not have the same rights as straight people, which of course is ridiculous and unfair. But real quickly, the right to bear arms in California has just suffered a very serious blow. Assault weapons have been illegal in California for decades, for obvious reasons, because they are used to kill groups of people, students, adults. And a federal court judge just ruled Friday that assault weapon ban in California is unconstitutional, which means we cannot ban in California the right of someone to go and buy 1, 2, 3, or 4 assault weapons. The judge said in that case, well, assault weapons are not really much more serious than the Swiss Army knife. Well, now the case is going to have to go to the Federal Court of Appeals, and ultimately it's going to end up again in the Supreme Court. And once again, I want to repeat that Donald Trump appointed 3 conservative justices to the court. And those justices are conservative, and they believe in the right to bear arms. If the Supreme Court decides that that law, that federal judge is correct, and that means that we cannot ban assault weapon purchases in California. There are many states that have the same ban. There should even be more states that have that ban. But if the Supreme Court says a person has the right to bear arms means assault weapons, can you imagine what that means? It means people, a lot of crazy mentally ill people, because obviously no one knows who's getting these guns, are going to have them. And we know what there's only one reason someone should have an assault weapon, only one, because they want to kill or injure many people at one time. They're not getting an assault weapon to go shoot a deer. It is frightening. So as I said before, the Donald Trump's influence is going to be frightening for many decades. Anyway, I want to thank you guys for coming on the show. Next week we'll have great guests, and we want you back. Love you guys.
Wallin Klarich Law hopes that you learned something about the law today. Knowing your legal rights is critical in 2021. Come back next week for more WK Legal Power Hour at 3 o'clock p.m. Pacific Time on Tuesdays. You can visit www.wklaw.com for thousands of pages of free legal information, or email the firm at pjw@wklaw.com. Wallin and Klarich will do their best to provide you with legal guidance or try to point you to the proper direction. That's pjw@wklaw.com. The show is podcast and is available on WK's KMET programmer page. Until next week, be safe.